then that's when you get the cease and desist.
Yeah.
So I've gotten one from, and I say like from the attorney, Madonna, Trent Reznor, Chuck D. I think that's it.
I'm excited about this. So not so much.
It's kind of fun. I think the first one I got, I was like, ooh.
Yes.
You are listening to the Capital Craft Podcast, brought to you by the San Diego Brewers Guild. I am your host, Eric Fowler.
My name is Jeff Fox. I'm with Beer Media Co.
And we are sitting down with good friend Candace Moon today. Thank you, Candace, for coming.
You got it. Thanks for having me.
Yeah, we're so excited to talk about everything trademark today.
Excellent.
But before we dive into that, why don't you give the listeners a little bit of background on who you are, what your experience in the industry is, and what you're excited to bring to the table today.
Okay. So my name is Candace Moon, and I am the craft beer attorney. I have been...
Is it trademarked?
You know, we'll have an interesting conversation about it. It is not, but not because I didn't try. I have been an attorney for breweries for 14 years. Yeah, almost 15 years. Only ever worked in the craft beverage space. Do everything from business formations to lots of contract reviews, lots of trademarks, alcohol compliance, licensing. Basically, the idea when I started was that anything a brewery would need that's legally related is something that we could handle. And then also some employment law compliance, but anything super in depth, we would pass off to a specialist.
Mm-hmm. And is there generally a lot of red tape for breweries to jump through that they would need, somebody like yourself services?
What I would say is this: a brewery can do it themselves, but it's probably going to take a lot longer and be a lot more painful than hiring either someone like myself or someone else who has experience in whichever area they're trying to work through, whether it be trademarks or licensing. Mm-hmm. It's very easy to screw things up and not know you screwed it up until it comes back to bite you.
Yeah. And if anyone's had to try to peel through regulations and read that kind of stuff on their own, then they'll appreciate what you do.
Is it mostly like ABC state regulations, city regulations, federal regulations that you're working with your clients on?
All of the above. Although I will say for the alcohol world, the locality in California is less of a factor. It's state licensing and federal licensing mainly. Although you do run into locality issues sometimes with zoning or actually I just had a client, we applied for their Vista business license and they need the stormwater department wants them to have a specialized license. So there's sometimes little things on that end.
Yeah.
But the ABC and the TTB are the two big ones.
I have a question. What would you say are some of the most common services that breweries need from you with a new client?
It's funny because for a long time it was trademarks. I constantly, and I still do a lot of trademark work, but right now, for whatever reason, it's licensing. Lots of people are doing new locations. There's lots of transfers. A lot of people starting to venture out of state, and every state's different. You got to do paperwork for every state.
Sure.
And I'm kind of surprised because I never would have looked at licensing as being such a big area. But I will say too, it's again, I always tell people it's not hard. It's not rocket science, but it is paperwork. It's tedious and you have to do it exactly the way the government wants to see it, or it gets bumped back or gets pushed back on you. So there is definitely a benefit.
And that time is valuable, right? And then also having to push back a release or a new location or something because the paperwork didn't go through or something. I mean, half the battle is knowing what forms to fill out in the first place. So
exactly.
Yeah. I mean, on even just the label approval side, when my past brewery was sending beer to the East Coast, we would be looking at a 6 to 8 week period because we would need time for when it got pushed back for the designer to go in and make changes. And then you had the lead time of the labels and the cans actually being printed. So we had to work backwards months on something that was fairly simple, at least on paper.
No, there's like you said, a lot of red tape, a lot of hoops to jump through. And yeah, the more correct it is to start, the faster it will go.
Mm. Well, I mean, when it comes to trademarks in particular, what are some of the things they do protect, and what are some misconceptions on things that they don't necessarily protect?
Well, I would say the biggest misconception is what people think a trademark is, like what gives them trademark rights.
Yeah.
I've definitely had clients in the past who are like, well, but I filed the business name. Yeah, that doesn't count. I have the website. I have the social media handles. None of those give you rights to a name from the trademark perspective. The only thing that gives you rights is either using the name, the logo, whatever the item is that you're trademarking on the goods that the goods are going to sell and for sale. You have to have all three of those. So for a brewery, I get this a lot. Well, what if we make a t-shirt? Nope. You're not a t-shirt manufacturer. You're a beer manufacturer. So to get your trademark for beer, it has to be on beer product.
Interesting.
Yeah. And for sale. So a home brewer has no rights to a name they put on their beer. Now that I will say, here's my legal caveat. There's always exceptions.
Right.
Lots of things can be argued, but general rule. And so the only other way is to actually file for a trademark.
So you can have a trademark without actually filing for it. And if you file for it, is every trademark that's been filed for and accepted equally as defendable?
Okay. So there was two questions in one. Let me see if I can. You can definitely have a trademark without a registration. And that's called common law, a common law trademark. So if you've used it, so let's say I opened Candace Moon Brewery in San Diego, and I sold beer with that name on it, I would have a trademark for Candace Moon Brewery in San Diego. So common law marks only go as far as actual use.
Okay.
So let's say then I sold it in Arizona. Well, then I would have Southern California and Arizona.
Yeah. How wide is that range? Is it city, county?
Oh, that's a fun legal argument.
Okay.
It's a area of natural expansion. So that's something that would get argued at the time. But from what I've seen in a lot of situations, and I don't count California in this group, but like the state. So if you're using it in Dallas, they give you Texas. California, because of the size, I would probably say, San Diego, you get Southern California.
Okay.
But again, that's all something that would be argued if you're actually fighting over that.
Right.
So the second part of I've already forgotten the second part of the question.
Oh, now you're testing me.
Yeah. Are they equally defendable?
Oh, equally defendable.
Yeah.
They're definitely stronger marks than others. So the strongest trademark you can have is a made-up word that has no meaning to anyone or anything else. I think Kodak was one. That was not a word for anything. Completely unique. Those are the strongest marks. Then you have words that have absolutely nothing to do with the product. That's kind of the second area. So Apple and computer software, very strong mark. Where you start to lose strength is especially, and it happens a lot in our industry, well, the alcohol industry, because there are so many breweries, wineries, distilleries, kombucheries, et cetera, and so many products that now we start to have similar names. So we'll have one word is the same, but then you'll have a second word with it that's totally different. And of course, I can't think of something at the top of my head, but it'd be like red table or red wagon or red this. And that's where it starts to get a little grayer, because the legal standard for trademarks is, will the consumer think that these two products come from the same place? So it's not, is the consumer going to think that red table and red wagon are the same? Because clearly we all know that wagon and table are not the same. Right. But could the same brewery put out a beer called Red Wagon and a beer called Red Table, which, well, yes, if their theme is something to do with red, that would be perfect,
Right.
perfectly potential.
Oh, I love a good red ale.
I know.
But jokes on them. The Red Table beer is not a red ale. It's probably an IPA. We all know that. So, I understand conceptually that this is important, but if I'm a small brewery and maybe I'm starting to distribute a little bit, maybe I'm doing events out of state because I get invited to really cool invitationals, or I'm doing these drop shipments, once a year to, areas like DC that are easy to do those types of things. Mm-hmm. Does this really apply to me as a small business that's maybe 7,000 barrels a year? Like when should I start considering the importance of this as a brewery? Is it size? Is it revenue? Or is it something right from the get-go I need to be keeping an eye on?
Again, everyone's going to have a different answer. My opinion on this one is your brewery name probably needs to be trademarked right away. Mm-hmm. And part of that, I will say this, and part of it is that people start with one idea. I'm going to be local, hyper local. I'm not going to do anything else. And the next thing you know, oh, well, this is actually going pretty well. Maybe we will go and spread a little further. Mm-hmm. So I'm a small brewery. I'm going to be hyper local. So I will have a trademark by using my name on my beer for sale where I am. So I don't need a federally registered trademark. Great. A few years go by, I'm doing really well. I want to expand. Well, in the meantime, someone else filed a trademark for the same name as my brewery. And guess what? I can't expand now. Mm-hmm. Now, they can't stop me from what I've already done because I was first.
Right.
And the U.S. is a first to use. But they can't stop me from going any further. Mm-hmm. Because they filed. Mm-hmm. And so the law is basically where you use it, you own it, and a natural every expansion. So Southern California, let's say. But someone who files would then basically get everywhere else. Mm-hmm. Now, granted, in that case, there's probably going to be a lawsuit. People are going to fight. But I don't think small brewery has the money, definitely doesn't want to spend the money on a lawsuit. And God forbid, this other company is a big company or someone with a lot of money who can afford to do a lawsuit. Mm-hmm. So I think that's where you get caught by not doing it in the beginning. It can hurt you down the road. Now, let's say they just want to stay they always just stay hyper local. Mm. No problem. But the problem is you don't really necessarily know that where you want to be, where you're going to be 5 years down the road.
Right.
10 years down the road.
We had a beer that we canned and it didn't really see any distribution. But it happened to come out the same week as another brewery. It's a very generic name. It was 10P. It's a style. But, being of Czech origin, very similar can design, exact same name. We had no idea that somebody else was releasing the same thing. We'd been working on it for months. And we knew it was coming out next week. Their social media pops up today. And it's like, damn. So we picked up the phone and called them and said, hey, this is small. Not stepping on anybody's feet, and it was fine. But mm-hmm. Is that common, or is it suggested to try to resolve these things sometimes outside of a formal letter, especially in such a casual industry?
Yes. And again, some lawyers will speak differently, but those lawyers are not in the craft beer industry.
Sure.
My number one suggestion when someone calls me to say there's an issue, I'm like, have you talked to the other person? So, and I will give one caveat to that, which is I appreciate the phone call because sometimes you want to make sure before you talk to the other person, actually where your rights stand. Mm-hmm. Like,
right.
So a lot of people are going to call and go, hey, that's my name. I need you to stop. And you want to make sure that they haven't had that name long before you did. And mm-hmm. you just don't know that because then they're like, well, hey, why don't you stop? Exactly. But I definitely believe that so many of these can be resolved brewer to brewer, owner to owner. Again, just like you said, like one thing, like, oh, hey, this is a super small release on our part. Do you mind if we go ahead and put it out? We're not going to do it again. And, mm-hmm. We're all on the same page. And I think I always tell people you will always be on both sides of this. Some days you're going to make the phone call. Other days you're going to get the phone call. And, I do always say this in presentations. I'm like, don't be a dick. That's really what it boils down to. Just be like, hey, I didn't know you were doing this, or I'm sure you didn't realize we had a trademark. Because again, a lot of people pick beer names. You're not looking up in the trademark database every single name, especially if you're a small brewery and you're not distributing yet.
You don't have a super big compliance team.
Exactly. I mean, it's the trademark database is not easy to search either. So, and generally people like if it's draft, that's a super easy name change. That's change the keg color and erase the board. If it is packaged, if you can let people sell it off, I mean, the point is to avoid consumer confusion. So let's say you're on opposite coasts. Well, right now there's not going to be consumer confusion, but whoever does have those rights, you do want to enforce them and say, hey, finish this run, sell it off, and then change it so that down the road we don't have consumer confusion.
Yeah.
At White Labs, we believe in the science and creativity that propels our industry. Our dedication to exceptional quality means we carry out the same standards and care for every batch for consistently superior products. We pride ourselves in fueling the brewing community by offering new product innovations, educational resources, and a collaborative atmosphere, empowering brewers to make the best beer possible. Check us out at whitelabs.com and follow us on Instagram at whitelabsyeast for the latest happenings. Happy fermentations!
Now is a harder time than ever for breweries to navigate the rapidly changing market, but Beer Media Co. is here to help. As a proud partner of the San Diego Brewers Guild, we are a full-service digital marketing and content creation company that works with San Diego breweries to reach new customers and create amazing engagement for their websites and social media accounts. If you're a small brewery owner trying to figure out this whole social media thing, or a large brewery looking to up their engagement, send us a message at info@beermedia.co because we know SD Beer.
Support for this episode comes from BSG, proud partner of the San Diego Brewers Guild and wholly owned subsidiary of the RAR Corporation. With the select ingredients, industry experience, and dedicated customer service you need to create outstanding beers, BSG is ready to assist you in everything from recipe formulation to troubleshooting. Located within easy reach of most breweries, BSG serves San Diego area brewers from Oceanside, California. Become a customer today at bsgcraftbrewing.com.
So I have experienced and have heard first-hand accounts of beverage manufacturers, whether in beer or tertiary beverage, send, letters stating that there's trademark infringement. And usually it seems to be from the big guys. Do they have teams that are just, on retainer that literally just look for people infringing on their trademarks?
Oh yeah. There's definitely a market for that. And it's not just the big guys, just so you know, but so I will say this, it is very easy, especially if you're looking for a specific class of goods, to track that. So the trademark office publishes once a week. It's called the Trademark Gazette, and it's all the marks that are up for approval, and they publish it for third parties to see if they have a problem with it. And it is separated by class. Beer is class 32, all other alcohol is class 33. So it's pretty easy, if you're a beer attorney, to just go and look at that section and see, is there anything that, could be infringing that we want to either file something with the trademark office to try and stop it from proceeding, and or send a cease and desist.
Right.
And I will say, it's funny. So sometimes the big companies can be jerks. And then other times I've had big companies be really pretty decent about it and let people use things. So like I had a winery, I think it was Gallo, had a problem with the beer name. And they basically were like, well, as long as it's canned only, they never bottle it, and it's limited to the Northeast, we're fine with it. Mm-hmm. Which I was really like, well, because, you assume these big companies with the money and they have in-house attorneys, so they're not paying, like anyone else would. And then I've had smaller companies who are a little nastier sometimes.
Because I think one of the big ones was Yellowtail, right? Like that was one of the big problem where a big problem came up, right?
It's interesting. That one wasn't, and I wasn't involved in that. That's why I can speak freely. So what what I remember interesting about that, so Ballast Point definitely had all the rights, especially in beer, but the trademark office does consider all alcohol the same. But the key there was I had read an article around the same time that Yellowtail, the winery, was thinking about going into beer.
Mm.
And so I'm assuming they were trying to prevent like getting ahead of it. And now it never went to court, and Ballast Point changed the name and then had a really big, beautiful new facility. So my guess is that Yellowtail just bought it from them.
Yeah.
And, or they settled
Right.
with a large amount of money. And basically Ballast Point just called it Pale Ale and left the fish on the cover. So everyone still called it Yellowtail. And
It's always Kolsch to me.
yeah, there you go.
That's funny. I actually had I was helping my wife with her fashion business, and we were trying to pick a name for it, and she actually went with Hell's Bells, and so that was interesting because we went to a trademark attorney, and I was told that you can't actually trademark song names, like they're not actually trademarkable or something like that.
Okay.
Yeah,
They're not trademarkable as song names.
Yeah.
You can totally use that as a trademark.
Okay, interesting.
That's like Apple, because Apple's not trademarkable. That's the public realm.
Yeah.
Like, well, but I can't trademark Apple for apples.
For sure. Reasonable. Yeah.
But I will say this, the difficulty, and I'm going to say this specifically in alcohol.
Right.
Because I've gotten a number of cease and desists from attorneys from musicians.
Okay.
Because something like a song or something related to them was used as a beer name or an alcohol name. And depending on who they are, I mean, some of them, maybe are super anti-alcohol and don't want to have that public
they share a
connection.
demographic, right? A lot of the same people that are interested in beer.
Yeah.
Well, and you have a lot of musicians who've started their own private labels.
Yeah.
Right.
Or done collaborations.
And when it comes to that, is using a band, like a song or a band name or something like that in your beer, what is the legality of that?
My favorite lawyer answer, it depends.
Okay.
So here's the thing.
Yeah.
A song name is illegal.
Yeah.
If it's the biggest hit of that band ever and it's a big hit that the public was going to go, oh, that's the one, let's go with Purple Rain.
Yeah.
Which I think everyone would go, well, that's Prince. So the public is going to make that connection. So if I name a beer Purple Rain, people are going to think that's connected to Prince.
Right.
And then it's whether or not the musician cares, or even, and again, this is where when you're a small brewery, may never even know about it.
Right.
But then do they have a problem with it? Do they think you're trying to profit off of their brand,
right,
et cetera? And then that's when you get the cease and desist.
Yeah.
So I've gotten one from, and I say like from the attorney, Madonna, Trent Reznor, Chuck D. I think that's it.
Like, oh, I'm excited about this. So not so much.
It's kind of fun. I think the first one I got, I was like, ooh.
Yeah. Ooh, Madonna.
They don't give a shit about it.
Madonna let us keep the name, just not trademark.
Okay.
Which is nice.
What a sweetheart.
Yeah.
What about a perspective on family names or regional names? I've heard you give a lot of lectures over the year, and you always touch on, say Vista Brewing Co. What would that look like? How enforceable would that be?
Good question.
Geographic names. So obviously we have some geographic names. We have San Diego Brewing Company in town.
Yep.
Generally geographic names, you can't get a principal register trademark, which is the ultimate, on a geographic name unless you have used it exclusively in commerce for more than 5 years. So that's how there are breweries in the industry that do have geographic names, but they're like the OGs. Like they've been around for so long. There was no one else trying to use San Diego as part of a beer name.
Yeah.
Whereas, now there's so many breweries, you're going to have a hard time using something for 5 straight years with no one else using anything similar
or something.
Exactly. Well, so if you've used it exclusively for 5 years, the idea of the law is like, well, no one else needs to be able to use it. So that's generally the reason you can't trademark a geographic name, a descriptive name, is that other people in the industry need to be able to use that. IPA.
Right.
Lagunitas could not trademark IPA.
When they tried, right?
They trademarked the label that said IPA on it.
Yeah.
And
it's pretty iconic.
It
label.
is,
Yeah.
but IPA cannot be trademarked. Virtually everyone needs to be able to put IPA, on a beer. So same thing with geographic. But then if you've done it for 5 years and no one else is needed to do it, well, then it must not be necessary. That's the theory of the law behind it.
Yeah.
And I will tell you, it is a pain to police that. So you have to police your own marks. So if someone else starts using a name like yours, you have to again, you don't have to send them a cease and desist. You start with a phone call, and let's say they tell you to pound sand. Well, then you probably need to send a cease and desist, because ultimately, if a whole lot of people start using your name or a very similar name on the same product, your mark is going to lose its strength. It's not going to function as a trademark. People won't hear San Diego on beer and assume San Diego Brewing Company anymore. And I'm just using them as an example because it's kind of an obvious one locally. They may think of, there's a San Diego IPA by somebody else, or a San Diego Pale Ale, or, and it starts to muddy the waters. And that the whole point of trademark is to know who made the product you're purchasing.
So it is cut and dry in some sense, but in practice, there's a kind of a gray area when it comes to a lot of this.
A little bit.
Yeah.
A little bit. And I think what happens too is you have people who will start using it as another name, not knowing there's an issue. And then the trademark owner has to go after it and has to. And I will tell you, Lee, being one of the nicest people in the world, never wanted to approach anyone about them using San Diego with a beer name. He definitely didn't want to send a cease and desist, but he didn't want to call. And I think that's true in this industry in general. Everybody's so nice. Nobody really wants to go, that's my trademark. Could you not use that, please?
Right.
Yeah.
But it'll happen a lot. And you do Kelsey, North Park Beer Co. You've got to stand up for it.
Yeah.
Attention brewery professionals. Are you looking to elevate your presence in the heart of San Diego's craft beer industry? Consider joining the San Diego Brewers Guild as a professional or affiliate member today. Access exclusive benefits designed to propel your craft to new heights. Gain entry to premier industry events and educational resources, and forge vital connections within our brewing community. Visit sdbeer.com to explore the full list of advantages that a membership offers. Join the Capital of Craft podcast and the San Diego Brewers Guild, celebrating craft beer in San Diego since 1997.
G'day, merry mates of the podcast realm. It's your feathered friend, the Tapwise Owl, flapping in to lend a wing to your brewery. An owl much wiser than me once said that recurring revenue is as delightful as a moonlit night. But let's face it, those loyalty programs from Arrive, Square, and Toast are a bit like a half-kicked emu egg. Fear not, for I am here to soar to your rescue. My magical membership system lets you automatically collect recurring revenue and shower your guests with rewards and bring them back to your taproom. How's it done, you ask? Simple, through your very own brewery app, mate. Custom branded, just for you. And here's the kicker, it works seamlessly with every point of sale out there. San Diego Brewery Guild members get up to $500 off. That's a bonza deal, so grab your owl whistle and give me a hoot. Nah, just kidding, it's not the 90s, mate. Hop on over to tapwise.com, that's tapwise.com, or give me a squawk at 760-283-8847. Don't forget to drop Eric Fowler's name for a little extra magic. Fowler, get it? No worries. Bit of a cranky parliament today. Cheers, Cobbers.
So before we wrap up today, let's put it into practice. Walk us through a brewery who has a beer. It's going to be a core beer that's widely distributed. What does that process look like, and what do we need to do to ensure that we maintain that trademark?
The very first thing you need to do once you've picked a name is make sure that you can trademark that name, that someone else isn't using it, and that you can get it through the trademark office.
And they will push it back if it doesn't.
Oh yeah, they actually, I believe they are encouraged to reject things.
Okay, what does that timeline generally look like?
Unfortunately, right now that
varies
timeline is 9 months.
Wow,
they are super behind.
Yeah, with another government shutdown looming. Yeah.
So
at the time of recording.
Yeah, it's going to be a long time. But if you do a really good clearance, you should have a really good feeling of whether or not it'll make it through.
What do you mean by clearance?
Clearance is making sure that no one else. Well, one, you want to make sure there's nothing at the trademark office that's too similar, because then you're kicked back right there. But then the second level of that is anyone else in the marketplace.
Yeah, so just due diligence.
Exactly.
Yeah.
Your due diligence to make sure that someone else doesn't already have those rights or can come after you. So remember the little brewery that's just using it in their market? And then
Squash them.
Well, they can actually come after
9 months
you.
later.
Yeah. They could, this happened actually to one of our local breweries who had chosen a name. It was a beer name. Not thinking there would be any issue, because this was, 14 years ago almost.
Mm-hmm.
And the brewery that made that beer ended up they are now a national brand. And so once they started expanding, they were really unhappy to find that one of their main core beers was the name of a brewery somewhere else.
Yeah.
And that got kind of ugly. Now they settled it. But that's where, from the get-go, you need to make sure that there's not someone out there who's going to be able to come after you, at least, again, for your brewery name.
Right.
That's the name you want to lock in. So you want to make sure, so for beer name, no one else is using it. Then you want to file it. That is going to be a long process, but here's kind of the key in the long run to make sure you keep that trademark. So when you are registering when you file a federal trademark to get to registration, you have to use that mark in 2 states minimum, because it's a federal mark. Otherwise you can get a state trademark, but I'll be honest with you, in this industry that it just doesn't really make sense. But you got to use it in 2 states. You don't have to sell in 2 states though. You have to sell somewhere. That's one requirement. The other is what's called use in interstate commerce, which just means it has to cross state lines. But I do prefer, because I think it's a lot safer, for it to be a public use, competition, festival, or sale. And with beer or any alcohol, competition and festival is a lot easier because there's a lot of steps and hoops you have to go through to sell into another state. And then you have to actually use that mark in multiple states continuously. And you guys can't see my air quotes.
Sure they can. It's depending on where you're watching it.
That's true. So I do feel that once a year is continuous enough, which is why your brewery name is easy, because you're going to go to GABF once a year, which kind of sucks for the Colorado folks because that's not out of state for them.
Oh, that's funny.
World Beer Cup is at least every 2 years. Festivals are generally once a year. Be careful with your beer names though, because especially if you're hyper local, your specific beers may not cross state lines once a year. You're not going to send the same beer to a competition every year.
Sure.
And when you get to the point of so when you're registered, your mark is good for 10 years, but between years 5 and 6, you have to reiterate that you are still using it. So you have to file something with the trademark office. I'm still using this in commerce and interstate commerce. And I have had a few clients recently who we get to the 5-year mark and they're like, well, we haven't made that beer in a few years. I'm like, well, then if you want to sign that you're still doing it, that is your business decision. But I cannot, sign that on your behalf that you're still using it.
Right.
But there is that expectation.
Do you think breweries are trying to manage too many trademarks then? You have a pretty good pulse on what types of beers people are making, how often they're rotating it, what their distribution looks like walking into a brewery. What's a reasonable amount? Like some of your clients manage at a time. Do you have some that just maybe have one, which is their flagship beer that everybody knows? Or do you have some that are crazy and is like a dozen trademarks that they're trying to manage?
I have both. I will say this. I think 15 years ago, people were filing everything. So my older clients have a lot more. These days, and I think partly too because times are tight, it's expensive. People just don't do it, and because you have to police it. So how protective? If you're not going to follow it and track it and keep up with it, or pay someone to do that, how important is it really going to be? Because here's the other thing. Here are the 2 thoughts I have. If I were a brewery owner, I would sink all my marketing money into my brewery name and logo, and I wouldn't name a damn beer. It'd be Candace Moon IPA, Candace Moon Amber. It's just, in my mind, not worth it.
Yeah, that makes sense though, because I mean, business models have changed so much in the last 15 years too. And it used to be, I'm going to start at this size and I'm going to distribute my red ale in 13 states on the West Coast, right? And people aren't really starting businesses with that model in mind. And maybe 15 years from now, we're going to be the opposite again and see that. But right now, we're not. We're seeing people hyper local and focusing on their geographic area. And some of the most successful breweries that I work with day to day are saturating a really small market as opposed to just spreading themselves thin and buckshotting it everywhere.
Which actually reminds me of what my second point was, which is if you did your clearance, so you know that no one else is using the name and you use it first, even if you're just local, you have grounds to fight someone else if they try to register it. So to some extent, you're going to have some rights. You'll have to spend money and fight to go that other distance, but that's less likely to happen than spending all the money you would spend on filing all the trademarks.
Awesome. Well, we appreciate you taking time today, as always, and supporting the Guild and all you've done over the years for the San Diego craft brewing community and, nationally as well. Where can everybody find you and follow up if they have more questions on trademarks?
So I am, oh, good Lord, let's see. Well, my website, which is craftbeerattorney.com. You can email me, or actually, this is even easier. And this comes to me, info@craftbeerattorney.com. That way you don't have to know how to spell my name, because I see multiple variations of it.
Yeah,
so.
That's fair. That's fair. And if you want to see more like this, make sure you follow us on all the different podcasting platforms, and you can follow us at social media. All the links will be in the description, and we hope to see you at the next episode.
Cheers.
Cheers.
Cheers.